I'm Drew Stevenson, and this is a lecture for my professional responsibility course. We're going to be talking about a few Supreme Court cases from the U.S. Supreme Court about state bar admissions and residency requirements. So there was a time when states would try to require or would only license attorneys who lived within their state. Now, why are we talking about this? For my students, first of all, this is basically a postscript to our lecture on Model Rule 8.1, which is about bar admissions and a little bit about the bar's authority and the obligation to tell the truth to the bar. Here we're talking about bar admissions and the state bar's authority to have a requirement that you live in the state. Now, I'm covering this because they ask about it very often on the MPRE. They don't ask about cases by name, any cases by name on the MPRE, but they give a hypothetical about a state that requires residency in order to get a license to practice law there. And then they ask you why this is wrong, like why this is unconstitutional, and you have to pick which basically constitutional problem applies. So let's take a look at this line of cases. One or more of them you may have encountered before in your constitutional law class. Our first big case in this area is the Supreme Court of New Hampshire v. Piper from 1985. Piper was a resident of Vermont. Now, for my students in Texas, remember, Vermont and New Hampshire are similarly sized states in New England that share a long border. And there's a lot of towns right on the border. Piper lived on the border in Vermont and could easily commute across the border into New Hampshire. She passed the New Hampshire bar exam and submitted her application to get licensed in New Hampshire. She wanted to work in New Hampshire, even though she currently lived in Vermont. Now, she included a statement of intent that she was planning to move to New Hampshire after she was admitted. But she had a husband and a new baby, and they had a house in Vermont, and eventually they decided not to sell their house. They were going to stay, and she could just commute across the border every day and work in New Hampshire. Well, the New Hampshire ethics rules at the time limited bar admission to state residents, so the state bar denied her application to be licensed there. She appealed this to the U.S. Supreme Court. And the U.S. Supreme Court held that residency requirements violate the Privileges and Immunities Clause. Now, for those of you who are only half listening, it actually really matters for purposes of the MPRE why the Supreme Court said states can't do this. It was not equal protection. It was the Privileges and Immunities Clause of Article 4, Section 2. States must have substantial reasons, the court says, to discriminate against non-residents, and the difference in treatment must bear a close or substantial relationship to those reasons. Now, for my students, the court gives an example. They say maybe there's a state that has a really unique, distinct legal tradition that's pretty different from the neighboring states, and only people who live there or have had legal training and experience there could really understand their quirky rules. And my students in Texas are probably thinking Louisiana. If any state could meet that standard, it would be Louisiana, because they have a lot of rules that are different from everyone else because of the Napoleonic Code. And so let's see what happens here. The next year, or I'm sorry, 2 years after Piper in 1987, we get the Frazier case, and it's from Louisiana. And a federal court in the Eastern District of Louisiana required as a local rule either residency or at least maintaining an office in Louisiana for admission to the bar. Frazier challenged this on equal protection and due process grounds. Now, I know you're thinking, why didn't they follow the same rule, the Privileges and Immunities Clause? Equal protection and due process sounds a little more intuitive to some people. Well, the Supreme Court, even though it's Louisiana and they're different, said it's not different enough. And the local district court lacked the authority to have this type of requirement, and they cited Piper, and they based their decision on the Privileges and Immunities Clause. They did say, though, that maybe some state is such a remote jurisdiction that they're really, really different from everyone else, and it would make sense to require that people live there in order to be admitted there. So 2 years after Frazier, we get Barnard v. Thorsten, which is about the U.S. Virgin Islands, and it turns out even that's not good enough. So they had a local rule, 56B, that said before an otherwise qualified attorney is admitted to the Virgin Islands bar, he must allege and prove to the satisfaction of the Committee of Bar Examiners that he has resided in the Virgin Islands for at least 1 year immediately preceding his admission, and that if admitted to practice, he intends to continue to reside in and practice law in the Virgin Islands. And so the Supreme Court said that this violates the Privileges and Immunities Clause. And after this, the cases sort of stopped coming, right? You're gonna have trouble finding a more remote, more distinct tradition than the U.S. Virgin Islands. Okay, here's a quick review question to see if you've been paying attention to this short video. Can a state bar refuse to license attorneys who do not reside in the state if they otherwise meet the licensing criteria? A, yes, because the 10th Amendment protects states' rights. B, no, due to the Privileges and Immunities Clause. Or C, no, due to the Equal Protection Clause. Hopefully you know the answer to this, and if you don't, you should really rewatch this video. Okay, that concludes our quick little lecture about the Supreme Court cases about state bars trying to have residency requirements, and the bottom line is they're not allowed to.